Hi, good afternoon. Welcome to Know the Law with Karen. I hope we're all staying well with the change in weather this week. It's definitely starting to get colder, maybe just in time for Easter. So today I've got three financial mistakes that I thought I'd discuss with you all that we've seen people experience while going through separation. So right off the bat, I'll start with one that we commonly see, and that is that clients coming to us and assuming or telling us that their friend or their family member's gone through a divorce or separation, and our client has the expectation that their outcome will be the same. We understand that going through separation and a divorce is oftentimes the most difficult experience you will ever go through. It's very challenging. There's a lot of emotions involved, and it affects people for longer than just the separation period. And it's very hard to see what the future will look like because there's so much uncertainty and so many moving pieces while you're going through the separation. So we always encourage our clients to, lean on their friends and family, especially those that have gone through separation, for emotional support. But what we do want you to be aware of and to be careful of is not to lean on them for legal advice and to not get legal advice from non-legal people. The way financial division is decided under the Family Law Act and what the court considers is different for every relationship, is different for every case that goes before the court. It considers what were the pre-relationship assets. So what were the assets that each party had before they started their relationship? Who had more super? Who had more other assets? If one of you potentially had a business or was entitled to a trust before the relationship started, that's relevant too. What were the contributions during the relationship is another factor. So that would be financial. So that could be who was paying for more of the expenses during the relationship, but also non-financial. That's valued just as much. And that's who was looking after the children more, who was taking care of home duties. So that's the second factor. The last one is what are the future needs of each party. So that takes into account any health conditions you have, your age, who's going to be looking after the children more moving forward, whether either of you are expected to have a windfall or a large sum of money of some kind, whether that's due to a deceased estate, a win or a compensation or a payout from another court case or something like that. That's the third consideration in terms of swaying the needle each way for how much each party gets. So as you can see, there's a lot of factors and it's never replicated from one case to another. So although it's good, as I was saying, to speak to your friends and family, for them to help you through this process and support your mental health and have someone to talk to about the experiences you're having and the feelings that you're going through, we just recommend that you don't get legal advice from them. The other mistake I wanted to talk about was also when it's also to do with actually chatting to other people. And it's at the time of separation, we've seen a lot of partners or spouses have a discussion about how they think their assets should be divided, which is a good conversation to have. From our experience, a lot of clients at the time they've decided to actually get legal advice and put their separation and formalize their separation, they've often had difficult times in the relationship for quite a while, and they probably have come to the realization that it's not going to work out. So they might have a dinner table discussion about, well, I think we should do this, or what if you kept the house and you just paid me out a certain type of money. It is a good thing to have that discussion, especially if the parties are amicable, so you know where each other's at, and as much as possible can remain amicable and have that line of communication open during the separation process. That's obviously the best case scenario. But we just want clients to be aware that they don't make the mistake of having really rigid thinking and thinking that, well, I've came in to a solicitor's office and I've told them I want this as my settlement. I'm not going to listen to any other advice. This is what I want, and we've decided on this. We try to give advice as a lawyer. It's our obligation to give you advice that tells you what your risks are with any step that you're planning on taking. And a lot of the times we see that clients believe they'll take on an asset after separation, and it might be agreed. So it might be that one party takes over the house, but they don't consider what are the ongoing costs of maintaining that asset, whether they're able to meet those costs. So it could be insurance, especially with interest rates rising. It could be, mortgage, especially with interest rates rising, and it could be paying for insurance or maintenance of a house. It depends on that party's own financial situation. Are they on Centrelink? Do they work casually? Is their job on a contract basis? So there's no guarantee of future income. They're all risks that are relevant to taking on, especially a big asset like a property. And the other mistake that people don't think about is also that when you're thinking of how to split up assets, and one of you potentially wanting to delay the sale of something. And it could be, for example, if you had a child that was in year 10 and you were thinking, well, we just want to create a stable environment for our son or daughter, so we're just going to not sell it for 2 or 3 years until after they've finished year 12. Although that is desirable and that it creates stability, there's also risks that your lawyer will be wanting to make sure that you're aware of and that we try to minimise when we do draft up that agreement. And those are that you should be prepared to have a financial relationship with your ex-partner for that period. So typically we try and draft settlements that sever, so they cut the financial relationship, because you're coming out of the relationship and you don't want to have, those emails and calls and text messages from your ex-partner arguing about payment or money, or whether we put up a fence or fix the fence, chasing them if they haven't paid you what that you agreed to. We're trying to avoid the ongoing relationship or contact that you need, and so that you both can move on and have financial independence and start the next chapter of your life. And so just a word of warning that if you are planning on keeping an asset for a little while and still having that financial relationship, you should be prepared for what the effect that might have on you. And that's why we always try and encourage clients. It's good that if you've got some notes written down about what you're hoping to come out of the separation with, but just also be open-minded and take on the advice that your solicitor may be giving you about the pros and cons of each option. And lastly, the last financial mistake I wanted to talk about was just to be wary, if you're going through a separation, of what your post-separation spending is and how you're using your assets after separation. The mistake that people make is that they believe that any assets or money that's in their own account, or you might have an account in your own name, or the house might only be in your name on the title, that means you can deal with it however you want after separation, that the other party may have hurt you in a certain type of way and you just want to take what you believe is yours and protect yourself. And that is incorrect. So even assets that are in your name, and assets that are in joint names, assets that are in the other party's names, they all fall into the joint asset pool. And that's what the negotiations and the settlement is trying to determine, how all of that lumped together is going to be carved up. So after separation, we don't recommend, and we caution people to not spend something that would be very different to what they were spending during the relationship. So For example, taking out a lot of money to go on a holiday, significant withdrawals or transfers to a family or friend or to a new partner, buying expensive assets, luxury goods, buying a lot of, it could be a new vehicle or a gift to someone else. Just be mindful of that. And selling any of the assets. And so any of the assets that you had, so for example, if you were going to list the property for sale because you're the only one on title, it's usually something that you'd have to inform your spouse about, and the money from the sale is usually held in a trust account, so that the parties can resolve and agree on how it's going to be split before it's released. So we just recommend that you maintain the same spending and lifestyle that you have had before. Obviously, there's no concerns if you continue to pay for school fees and groceries and insurance, mortgage, things that it's expected you'd need for your day-to-day life. But just be wary if you're making any big financial purchases or decisions, or getting rid of assets, to discuss that with your solicitor, so you know what the consequences of that might be. And it could result in what we call an add back, where what you've taken away from the asset pool or what you've received a personal gain from, it's added back in nominally when the parties negotiate the percentage that each person gets. So they're the three that I've decided to discuss today. 3 financial mistakes, being from top to bottom. We discussed that not to assume that every case in family law is replicated and that there's some type of formula or predetermined calculation that you will definitely get this outcome because someone else got this outcome. It has to be specific and sit comfortably with you and the other party. And the second one we discussed was when you've had conversations with your ex-partner and you've decided on how some things might be divided, to be open-minded when you come in with the solicitor giving you advice about what are the risks, especially when it relates to having an ongoing relationship that you might not have considered with your partner if you decide to co-own property for a certain period of time after separation. And the last one is to do with post-separation spending and disposing and acquiring assets after separation. So thanks for joining me today on this lovely afternoon to have a little chat about family law and for me to share a short session of legal knowledge. If you'd like to discuss any further or got any specific family law questions you'd like us to discuss in future lives, please get in touch with us. Our number's on the screen, 57942334, or you can also email us at admin@tbalaw.com.au. Please tune in to my colleague Ivy. Her next live is on discussing the difference between parenting plans and consent orders in her session called Ivy Informs. That's on the 25th of April at 1 p.m. And of course, there's always Join Jackie every Monday at 10 a.m. That's all from me today. So thank you and hope you have a lovely afternoon and take care. See you next time.